All right, so welcome to our first video from blackdebt.net. We're going to be talking about today what to do if you've been sued by a debt collector. Ugh. All right, so it's Friday afternoon. You're just home from work. Someone walks up to you, verifies your name, and hands you a packet and says you're served. Yep, you've been sued. Don't worry, it's not the end of the world. Here's what to do. First and foremost, please do not ignore it. Guys, judgments do not go away, okay? The reason you shouldn't ignore it is because what happens is they will get something called a default judgment, okay? Once that happens, they have a lot more leverage to collect the debt. Also, you may think now that you don't care because you don't have any money for them to take, but here's the thing, judgments don't go away. So that means if 10 years down the line, maybe you get an inheritance or some money comes your way, they can, bam, come in and take it. And think that doesn't happen? Google some legal advice forums and you'll see people, complaining about wage garnishments from debts that they had long forgotten about. So, yeah. All right, so let's talk about what you should do. You need to file an answer. You can file a simple two-sentence answer denying that you owe the debt. It's as simple as that. But the better answer to do is to make sure that they have the right to legally own the debt. The collection agency must prove that they legally own the debt. In order to do this, they must prove they have the right to collect, as evidenced by a transfer of the signed agreement. Believe it or not, most collection agencies are sloppy operations, and they don't keep the necessary paper trails. All right, so you filed your answer, they responded, they're not backing down. That's all right. Next year, you're going to fight back with knowledge. The statute of limitations is your friend. Statute of limitations basically says how long a debt collector has to sue you. And if it's outside of that time limit, you win. Doesn't matter whether you actually owe the money or not. And I'm going to go ahead and put a link in the description box so you can check the statute of limitations in your state. So you've checked the statute of limitations. Unfortunately, it's still within the time limit. That's okay. There's still some more tricks up our sleeves. Next would be to file a countersuit. You have a lot of rights under the Fair Debt Collection Practices Act. And if any of those rights are violated, you may be able to countersue the debt collection agency for damages. Now, here's just a few of the rights that you have under the Fdcpa. First and foremost, you have the right not to be called at inconvenient times. The generally accepted times call you would be between 8 a.m. and 9 p.m., unless both parties agree otherwise. Next, you have the right to dispute and request validation of the debt. And I'll put a link to that in the description as well. You have the right not to be lied to, or they can't use any false or deceptive means to collect the debt. They're not allowed to call your friends and family about the debt. You have the right not to be called multiple times a day just to harass you. You have the right not to be cursed at or have abusive language used towards you. They can't embarrass you by publicly disclosing the debt. You have the right not to be contacted once you've sent a cease and desist letter. I'll put a link to that in the description box. The number one violation debt collectors usually commit is calling you too many times, which constitutes harassment. This is usually your easiest way to win a countersuit. Why? Because the statute doesn't set a specific number of times a debt collector can call you before it constitutes harassment. That means it's vague and left up to courts to interpret. This is why it's so important to keep track of the number of times a debt collector has called you. This can be your ticket to winning a countersuit and coming out of this on top. Another easy avenue of success is the fact that debt collectors often inflate the amount that you owe in order to intimidate you into paying up. While they are allowed to charge interest, they can't add extra fees or anything like that. So, for example, they can't add a debt collection fee or anything like that unless it was stipulated in the original contract. If you are successful, you'd be entitled up to $1,000 per lawsuit, in addition to punitive and economic damages. And they'd also be required to shoulder your attorney's fees. That being said, it is vital that you contact a licensed attorney prior to any lawsuits. That's because the law can be tricky, and so you need someone with experience to help you. The good news is that attorneys are not as inaccessible as you think. There's so many lawyers out there. A lot of them offer free consultation, and if they think you have a case, they can do what's called contingency. That means that you don't pay unless they win. Kind of like the personal injury car accident attorneys. So, yeah, get a lawyer. And I guess your last option is to go ahead and BK. It's not that hard. You can get a lawyer to do it for you. They're going to charge you 11, 1200 bucks, 1500 bucks. But most consumers are going to file either a Chapter 7 or a Chapter 13 bankruptcy anyway. It's pretty straightforward, if you don't have any significant amount of assets. You can just do it yourself. Save yourself $2,000. I'll put a link to a do-it-yourself bankruptcy guide in the description box. And really, finally, don't get to the point where you're getting sued in the first place. If you're drowning in debt, you can get a debt consolidation or a debt settlement. There's the debt relief agencies that can help you. National Debt Relief, it's pretty good. My auntie used them. She was happy with the results. I will put their phone number and a link to them in the description box. All right. Thank you very much. If you have any questions, please leave them in the comment section below. Thanks.